We saw the.
Mic check, 1, 2, 3. Good morning, everybody. The time is now 9:15. We're going to go ahead and do our first captions check for our online broadcast. As a kind reminder for those that are coming up to speak, please make sure that the yellow light is on before you begin speaking. So that way, or green, I'm colorblind. Make sure the light is on so that everyone can hear your voice coming through the speakers as well as through the broadcast. And before you leave, make sure you push the button to mute it so that it does not pick up any unwanted conversations in the front row. And I'm going to do that right now. Hello, hello. So that is the difference that you can hear in the volume. Thank you very much. Final mic check. Test 1, 2, 3. Good morning, everyone. Time is roughly 9:25. We'll get started here soon. As a kind final reminder, please make sure that the light is on before you begin speaking. And when you leave the podium, to make sure that you tap the push button here to mute the microphone. You might have to get a little close and roughly have like 6. Got a little echo there. We're watching the YouTube stream. Thank you. So just go ahead and push the mute button before you leave the podium. And also, if you can't be heard, you are more than welcome to get a little bit closer to the mic, as you will get louder as it picks up roughly about 6 inches away. I'm going to mute the microphone now. Close enough. You guys ready? Yeah. Okay.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 14th, 2024. The time is 9:30 a.m. With us today are Commissioners Bobby Janeka and Katarina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. Registration has now closed, but if you'd like to address the Commission on a particular item, I'd invite you to visit our registration table or email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate the request. For those who are addressing the Commission, our General Counsel or I will let you know what your time limits look like, and we'll let you know when it's your turn. I want to thank everybody for being present today, and Ms. Smith, I'll ask you to please go ahead and call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the Executive Director's denial of the application of Cody Lee Rancher for a water system operator license. The parties have been notified that the order of presentation will be the applicant, the ED, OPIC, and OPIC, and that each party will have 5 minutes of oral argument time. The applicant may reserve a portion of his time for rebuttal as he bears the burden of proof. And so with that, we should begin with the applicant, Mr. Rancher, if you are here or online.
Mr. Rancher, are you in the room or with us virtually? If you're trying to join us virtually, you might double check your mute button. Are you there, sir? All right, let's come back to Mr. Rancher and hear next from the Executive Director's office. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Aubrey Pawelka, representing the Executive Director. With me today is Haya Zeman, Deputy Director of the Occupational Licensing and Registration Division. While the Executive Director had initially recommended denial of Mr. Rancher's license, the ED, upon further review of the record, and the PFD agree with the Administrative Law Judge's proposal for decision and proposed order. The ED respectfully recommends the Commission adopt the LJ's proposal and order. Thank you, and we are available for questions.
Thank you. I have none. Colleagues, any questions? All right, let's hear next from Public Interest Counsel. Good morning.
Good morning. Chairman, Commissioners, Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in the hearing, evaluated the evidence and arguments presented, and initially concluded that the record provided good cause for denial of Mr. Rancher's license. However, upon reconsideration of the record, in conjunction with the Administrative Law Judge's proposal for decision, OPIC would now recommend that Mr. Rancher's license be granted. Mr. Rancher has demonstrated his rehabilitation. He testified that he served his time in prison, completed parole with no issues, and is now no longer on parole. Additionally, he testified that he successfully completed a lie detector class after his time in prison and did not have to attend sex offender rehabilitation based on the results of that class. Mr. Rancher has not been involved in any crime since this 2015 incident. Further, Mr. Rancher was 18 years old at the time of that crime. While in prison, Mr. Rancher earned his GED. He is currently employed by CNR Water Incorporated, and his employer is aware of his past criminal history. Further, he was employed by CNR Water prior to his incarceration, and 2 of his colleagues testified to his character at the hearing on the merits. Turning to the Occupations Code, the ALJ found that the grounds to deny Mr. Rancher's application do not exist under either Code Section 53.021A2 or Code Section 53.021A3. Although the offense Mr. Rancher was originally charged with, sexual assault under Penal Code Section 22.011, appears in both articles, the offense he was convicted of, attempt to commit sexual assault, does not. Mr. Rancher's conviction for attempt to commit sexual assault was therefore not a conviction under Penal Code Section 22.011. Occupations Code Section 53.021A1, regarding an offense that is directly related to the occupation, provides the ED grounds to deny Mr. Rancher's application. Mr. Rancher's offense is directly related to the occupation of water system operator, considering the factors prescribed in Code Section 53.022, the actual work to be performed, the access required to perform that work, and the opportunity he would have to reoffend. Before denying his application on these grounds, however, the Commission must determine whether, despite his criminal history, he is fit to be licensed. This can be done by weighing the factors in Code Section 53.023A. While Mr. Rancher's crime was a serious offense, Mr. Rancher's earlier referenced examples of rehabilitation support his efforts and help weight the factors in his favor. Chapter 53 has codified the legislature's intent to increase opportunities for individuals who are convicted of an offense and have discharged the sentence for the offense. Additionally, the legislature has directed that this chapter be liberally construed. While Mr. Rancher's crime could be sufficient for the commission to deny his application, a liberal construction of Chapter 53 would encourage granting Mr. Rancher the license. Between Mr. Rancher's rehabilitative efforts, the ALJ's discussion of the penal code, and a liberal construction of Chapter 53, OPIC recommends that the commission grant Mr. Cody Lee Rancher the license. Thank you, and we are available for any questions.
Thank you. Colleagues, any questions for SOA? Seeing none. Mr. Rancher, have you been able to join us? All right, I think we should go ahead. Colleagues, I agree that Mr. Rancher demonstrated his fitness for this license, and I don't see any reason to change the proposed order.
I'm in agreement.
Also in agreement.
I think we're ready for a motion.
I move that we adopt the administrative law judge's proposed order.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye, the motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the application by Municipal Operations LLC for the new TIPD's permit number WQ001-617-1001. And the parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Thank you, Ms. Smith. I just want to acknowledge that there are a number of people who are in attendance today in opposition to this application. I appreciate that. Just to make sure that everybody's on the same page, the matter that's before us today is considering requests for a contested case hearing. So what's before us today is not about the merits of the application or the substance of the application, just whether we're going to grant a request for a contested case hearing. And Chapter 55 of our rules provides a two-part analysis for that inquiry for evaluating hearing requests. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester meets those requirements, we then consider which issues are appropriate to refer for a hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. And I think I might add that what's relevant and material to the application is what the law prescribes for the commission to look at in determining whether this person has a particular personal concern that's within our jurisdiction. Sometimes we call it a personal justiciable interest. Associations can have standing if, among other factors, they identify a member of the organization who would or could have standing in their own right. And governmental entities can have standing if, among other factors, they demonstrate a statutory interest in or a statutory authority in or another interest in issues relevant to the application. Now, colleagues, we have numerous requests on this application, and let me just begin with the Greater Edwards Aquifer Alliance. I agree with the executive director and OPIC that this association has indeed met the procedural and substantive requirements to be entitled to a hearing, including the identification of members who live within 1.25 miles of the proposed facility. Given the discharge rate of 1 million gallons per day in the final phase, I think it's reasonable to conclude that these members are affected in a manner different from the general public and could have standing in their own right. There are 4 governmental entities that requested a hearing. I would grant the request of the San Antonio Metropolitan Health District. The district's authority derives from the City of San Antonio's Home Rule Authority under Chapter 551 of the Texas Local Government Code and includes responsibility for public health, which reasonably implicates the protection of water supplies. I would deny the other three governmental requests. SAW failed to file timely public comments. In my view, the city of Gray Forest is not quite close enough to the proposed outfall to be affected in a manner different from the general public. Its ETJ being more than 1.5 miles away and its city limits roughly 2 miles away. The Helotes City Council did not cite sufficient statutory authority over or interest in the matter, and Helotes itself is more than 5 miles downstream from the site. Turning to the numerous individual requesters, nearly all of them failed to meet one or more requirement. Some reside too far from the proposed facility to be affected in a manner different from the general public. Some failed to submit timely comments, and some failed to raise a personal concern that is relevant and material to the application. In my analysis, colleagues, Elizabeth Ann Topperwine is the only individual who met all of the requirements, so I would grant her request and deny the others. So to sum it up, I've found 3 affected parties and think that we should refer their request to SOA for a hearing. And again, those are the Greater Edwards Aquifer Alliance, the San Antonio Metropolitan Health District, and Ms. Topperwine. So let me pause there and see how you came out.
I appreciate you laying out your analysis, Chairman. I reached the same conclusion in terms of parties and their respective effectiveness.
Thank you, Commissioner.
Yes, and analyzing this under our rules and the law, I reached the same conclusion as to those 3 parties being the
Okay.
affected ones.
Thank you. Well, let me turn to the issues. I think the 3 requesters did a very capable job of preserving a suite of issues on this matter. And so I would refer the following concerning the draft permit, whether it's adequately protective of water quality, including surface water, groundwater, and water and drinking water wells, whether it's protective of endangered species and other wildlife, whether it adequately addresses nuisance odors, whether it meets the siting requirements regarding floodplains and wetlands, whether the notice requirements were met, whether the operator is adequately identified, and whether the commission should deny or alter the terms and conditions of the draft permit based on need or regionalization as those policies are understood under Chapter 26 of the Water Code. So that's how I would define the issues. Commissioner Janetka,
I'm in agreement on those issues.
Commissioner Gonzalez.
I agree with those issues.
Okay, I think we're about ready for a motion. Let me just add that I would deny the request for reconsideration since I don't see that they present any new facts. I would include a referral for alternative dispute resolution along with the referral to SOA, and I would allow the full amount of time permissible 180 days for the hearing.
I'm good with that. Those decisions.
Do you need a motion?
I think we're ready for a motion.
I move that we grant the hearing requests of the Greater Edwards Aquifer Alliance, the San Antonio Metropolitan Health District, and Elizabeth Ann Topperwine, that we deny all remaining hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of water quality, including surface water, groundwater, and drinking water wells. B, whether the draft permit is protective of wildlife, including endangered species, in accordance with the Texas Surface Water Quality Standards and 30 Texas Administrative Code, Chapter 307. C, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13E. D, whether the draft permit complies with siting requirements regarding floodplains and wetlands in accordance with 30 Texas Administrative Code, Chapter 309. E, whether applicants substantially complied with applicable public notice requirements. F, whether the applicant adequately identified the operator in the application. And G, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code Section 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code Section 26.081. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of adoption of the renewal with amendments of TIPD's general permit number TXR 040000, and the executive director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Rebecca Villalba with the Water Quality Division. With me today is Aubrey Pawelka from the Environmental Law Division. Staff requests adoption of the renewal with amendment of TPDS General Permit Number TXR 040000, known as the Phase 2 or Small MS4, which is Municipal Separate Storm Sewer Systems General Permit. This general permit authorizes the discharge of stormwater and certain non-stormwater discharges into surface water in the state from small MS4s located in urban areas with a population of at least 50,000 people as defined by the U.S. Census Bureau every decennial census. The renewal with amendment will replace the current general permit, which expired on January 24, 2024, and is currently administratively continued. The general permit specifies which small MS4s must obtain permit coverage, which must be eligible for waivers, and which are required to obtain individual permit coverage. The draft general permit was approved by US EPA on June 9th of 2023. Public notice of the proposed general permit and public meeting were published in the Texas Register and the Houston Chronicle on August 25th and August 18, 2023, respectively. A public meeting was held on September 18, 2023, and the public comment period ended on the same date. Staff received comments during the public comment period, revised the general permit and fact sheet in response to those comments, and developed a response to comments document, which is included in the backup material before you today. Staff respectfully recommends adoption of this general permit and the executive director's response to comments. Staff also requests permission to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. We're available to answer any questions.
Thank you. Colleagues, any questions? Seeing none, thank you. Appreciate that. Ms. Smith, has anybody signed in to speak on this item?
No one has signed in to speak.
Thank you. And good morning, Ms. Mehta. What does the Public Interest Counsel's office think?
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta on behalf of OPIC. Our office has reviewed this proposed renewal with amendment of the general permit. OPIC understands that revised general permit includes a comprehensive general permit option rather than the two-step or procedural general permit option. In the course of this process, a public notice was issued and the Commission received 19 formal comments or letters, which together contained 81 individual comments. The comments covered a wide range of concerns, including the comprehensive general permit option itself. Changes were made to the draft permit in response to comments. OPIC agrees that this comprehensive general permit option would not change the information shared with the public about the controls implemented by permittees, but it would simplify the public notice process by giving the public an opportunity to review and comment on the comprehensive master general permit. OPIC supports adoption. Thank you.
Thank you. Bear with me, colleagues. Right. Okay. I do have a question for Executive Director staff. Now, the recommended permit, I understand, needs some edits, and we're trying to determine whether those are substantive or non-substantive. I think we're ready to move forward with non-substantive, and specifically, there's a question about a date that needs to be revised. And is that date a substantive concern or a non-substantive concern?
No, we were identified yesterday that we have a date that references, since the permit was supposed to be issued in January, and we delayed it till now, there's a date in there that is past. And so now we move to present regarding the annual reporting period.
Okay.
So would you like to include that in your motion to
What I-
allow that change to be made?
Well, I think, I mean, I would consider that a non-substantive change. Is somebody going to challenge this based on? We're going to have an attorney-client conversation. And I appreciate the explanation. And colleagues, let me do this just to cut to the chase and offer a motion, and let me know if this doesn't work. Colleagues, I'm going to move that we adopt the renewal with amendments of the Texas Pollutant Discharge Elimination System General Permit number TXR 040000 as recommended by the Executive Director, and allowing for changes to that general permit, both non-substantive and to the extent that revising the dates in the permit are substantive, to also allow those as has been described in the testimony today.
I second the motion.
The motion has been made and nodded to.
Well, no, you seconded. You made
I
it.
seconded.
Oh, okay, I'm sorry. Oh, yeah, that's right. I'm out of order here. Yeah, right. I made it. You seconded it. You nodded. Okay, it feels unanimous. Let's take a vote and find out. All those in favor say aye.
Aye.
Aye, the motion carries. Ms. Smith, when you're ready, please call the next item. Oh, no, that was me.
Item 4 is the consideration for adoption of 2 draft total maximum daily loads for indicator bacteria in Big Creek of the Brazos River Basin. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today is Aubrey Pawelka with the Environmental Law Division, and Wyatt Eason with the Total Maximum Daily Load Program is joining us virtually. Today, the Executive Director is requesting the consideration for final adoption of 2 total maximum daily loads for indicator bacteria in Big Creek. The TMDLs cover 2 assessment units and 1 water body within Fort Bend County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. I have none. Any questions, colleagues? Seeing none, Ms. Smith, is anybody signed in to speak?
No one is signed in.
What says OPIC?
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm with the Office of Public Interest Counsel. For the record, OPIC supports adoption of the 2 proposed TMDLs for indicator bacteria in Big Creek as required by the Federal Clean Water Act, Section 303D, for approval as certified updates to the State of Texas Water Quality Management Plan. We note that the comments from the EPA concerned only typographic errors that were subsequently corrected, and that the public comments involving additional monitoring stations will be properly heard and considered during future implementation plan proceedings. There have been 8 stakeholder meetings on this item since 2019, which provided education and opportunities for comment. So we are satisfied that there have been appropriate public outreach and participation measures that were utilized in this process.
Thank you, Mr. Martinez. First, I want to just again thank the Houston-Galveston Area Council's ongoing support of this work. I want to thank our stakeholders for all their contributions. And colleagues, I'm ready to go ahead and adopt these TMDLs.
I move that we adopt 2 total maximum daily load for indicator bacteria in Big Creek of the Brazos River Basin in Fort Bend County as recommended by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is the consideration for adoption of 2 draft total maximum daily loads for indicator bacteria in the Oyster Creek watershed of the San Jacinto Brazos Coastal Basin. The Executive Director's staff is here to present.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today is Aubrey Pawelka with the Environmental Law Division, and Wyatt Eason with the Total Maximum Daily Load Program is joining virtually. Today, the Executive Director is requesting the consideration for final adoption of 2 total maximum daily loads for indicator bacteria in Oyster Creek. The TMDLs cover 2 assessment units in 2 segments within Brazoria and Fort Bend counties. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you again, Ms. Hall. I have none. See none. Ms. Smith, is anybody signed in to speak?
No.
Mr. Martinez?
Good morning again. OPIC supports adoption of the 2 proposed TMDLs for indicator bacteria in the Oyster Creek watershed as required by the Federal Clean Water Act, Section 303D, for approval as certified updates to the State of Texas Water Quality Management Plan. We note that no comments were received from the EPA or the public, and that the Oyster Creek Coordination Committee has conducted frequent meetings providing education and opportunities for comment. So we are likewise satisfied that there have been appropriate public outreach measures and participation opportunities in this process.
Thank you, Mr. Martinez. Again, thanks to Houston, Galveston Area Council and to our stakeholders. I'm ready to adopt these TMDLs.
I move that we adopt 2 total maximum daily loads for indicator bacteria in the Oyster Creek watershed of the San Jacinto Brazos Coastal Basin in Brazoria and Fort Bend counties as recommended by the executive director.
Second motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to the enforcement docket, which are items 6 through 61, and the executive director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 61. The total assessed administrative penalties are $2,422,512, with $177,791 deferred, $911,404 applied towards supplemental environmental projects, and $1,333,317 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. Colleagues, any questions?
I have a question.
Yeah.
Can you explain to me the process you go through on when there's a financial inability to pay?
Good morning. I'm Melissa Cordell of the Enforcement Division. So when we develop our enforcement case and we send out the initial proposed agreed order, then we have a cover letter that goes with those draft documents with the order, the penalty calculation worksheets, the compliance history. And in that cover letter, there's reference to some of the options that people may pursue. So if they feel as if they have a financial or not able to pay the penalty in part or in whole, then they can basically follow the instructions and we'll work with them to get the proper documentation that the financial folks will need to conduct that review. So it does leave our division, goes to another division, they review, and they may ask for additional documentation or something like that. And so they will actually, in conducting that review, they will determine if they can do pay or pay full or part of it, and they'll draft a memo and send that to us at that point. Depending on what the results of that evaluation are, then we will incorporate that into the order or leave it as is. Does that help? Is that what you're looking for?
Sort of. A question is more, it's a pretty robust look at finances, right? I mean, this isn't just.
It includes looking at their tax records and things that they have filed. So there is a lengthy list of requirements.
Okay. Thanks.
Any other questions? All right, thank you. Ms. Smith, do we have folks signed in to speak?
So on items 7, 15, 17, 18, 21, and 23, we have people who are signed in but don't wish to address the commission. And then on item 56, we have Anthony Prihoda here. in the
Mr.
room.
Prihoda, good morning, sir. Thank you for being here. I'll ask you to come up to this podium here. Yeah,
You're up.
it's your turn. Yeah, we like to move through the business. And the first thing I'll have you do is make sure you've got a green light on that microphone. There's a, okay. Yeah, and if you'll give us,
Oh, there we go.
there we go.
It was a very litly dim green light.
There we go.
Just to address some concerns I have. I know ignorance is not an excuse, and I've always strived to be in compliance with TCEQ standards. I'm just here to address concerns involving correspondence with TCEQ. We moved our business in 2017 and our mailing address had changed. And this citation we had got, which we paid and we're trying to straighten out, I think was addressed from 2017. So basically, correspondence issues with TCEQ has been very frustrating on certain matters involving compliance, including records not lining up, structural changes involving a LLC, which we are not. We are a sole proprietorship. We have 7 employees. We're a very small company. Also, we had wrong addresses on correspondence from TCEQ. So I don't know if we were getting a lot of correspondence through mailers. Spent a lot of time and money to straighten these issues out to the point of hiring Wyson Engineering of Columbus, Texas to start taking care of all my issues beginning this year. So anything that may arise is being taken care of by a professional from now on. But I just basically wanted to say it's been a very frustrating experience for us just because of not having correspondence. We're not even for sure what we got involved in 2017 with this matter, but hopefully it's getting all straightened out.
Okay, well, thank you very much, sir.
And that was it.
I appreciate you sharing your experience with us about that. You do raise one concern for me,
Okay.
as I think I'm noticing that this agreed order is with an LLC.
Yes, and we are not an
And you've
LLC.
never been an LLC?
We, at one point back in 2020, looked into it. We had a lawyer involved.
Yeah.
And I think he may have started the paperwork on it, which may have made it to whatever, wherever it goes. And then we decided against it because of different things involved.
Sure.
So, and ever since we've been an LLC.
Okay.
And so the records never line up. So it's very hard to get things initiated or done with TCEQ when the records don't line up.
Okay. Okay.
They're looking at us as being, I'm looking as being one entity and they're looking at us as being another entity.
Right.
Yes.
That is an issue. That is a problem.
We're trying to straighten it
Yeah, and
out.
I'll ask staff about it in just
That's
a
right.
moment. But thanks for coming.
Yeah,
out
that
to the
it's
meeting
just
today.
concerns. That's all.
Yeah, and really appreciate your efforts to be a good actor.
And
be
we're
in compliance.
trying to take care of it.
Yeah, yes, sir. Okay, thank you.
Appreciate you getting me in early.
Thank you, sir. Well, back to Executive Director's staff. Question about the form of this agreed order, whether we're confident in the way that the parties are named or whether we might want to go back and take another look at it.
When we develop the case, we have information from the regional office indicating what entity to pursue. And then part of our screening process is to go through and check Secretary of State in our central registry to make sure that we have the appropriate party. We even go into the articles of incorporation and making sure that we have the right party. So based on that process, then that's what we would have followed in developing this particular case. I'm unable to actually open. Oh, I just received a note indicating that the LLC is what appears in the Secretary of State. So that's how we developed the case, if that's helpful.
It is helpful. They may have formed an LLC without appreciating that. What I'm trying to evaluate is whether we save ourselves a problem by remanding this and taking a fresh look at it or not. My notion is that we should probably just go ahead with it as it's currently styled, since that's what's shown in the Secretary of State's database. And appreciating that there may be a little bit of risk in that, but I think I'm in favor of moving forward, but I want to defer to your recommendation on that.
In consideration that they are in compliance with the violations and that they've fully paid the penalty that's laid out in the order, I think we would be comfortable with continuing as it is.
Okay, going ahead and entering this order. Okay, I'm very comfortable with that recommendation. Okay, I'm seeing nods up here. Ms. Smith?
No one else signed in. That's it.
Okay, that takes us to you, Mr. Arthur.
Good morning, Chairman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC reviewed this enforcement docket, and we support adoption of these enforcement orders as presented by ED staff.
Thank you, sir. Colleagues, I'm in the same place. I'm ready to move forward.
I move that we adopt items 6 through 61 as recommended today by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 62 is the consideration of the publication and hearing on proposed amended sections of 30 Texas Administrative Code, Section 350.76 regarding the Texas Risk Reduction Program, and the Executive Director staff is here to present this item.
Good morning.
On behalf of the Executive Director, I'm Scott Sedemeier.
Mr. Sedemeier, hold on a second. I was hearing you fine, but I think the mic wasn't picking you up, which is important for the folks watching at home. So you'll start from the top again.
Thank you.
Thank you.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Scott Sedemeier with the Remediation Division. With me virtually is Michael Martinez with the Environmental Law Division. The proposed rulemaking would amend 30 Texas Administrative Code, Chapter 350, Texas Risk Reduction Program, Section 350.76, to update the chemical-specific approaches used for developing and demonstrating attainment of the critical human health protective concentration levels for dioxins, furans, and dioxin-like polychlorinated biphenyls. A public hearing will be offered on this proposal in Austin on Monday, September 30th, 2024 at 9:00 a.m. in Building F, Room 2210. Staff respectfully recommends approval to propose the publication of and hearing on September 30th, 2024 for the Chapter 350 Texas Risk Reduction Program Rule, Section 350.76. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you, Mr. Sedemeier. I have none. Colleagues, any questions? Seeing none, Ms. Smith, is anybody signed in to speak?
No one has signed in.
Thank you. And what says the Office of Public Interest Counsel?
Thank you, Chairman. Good morning, Commissioners, General Counsel, ED staff. My name is Josiah Mercer with the Office of Public Interest Counsel. We have reviewed the rule proposal package and we support publication. The proposed rules would update outdated chemical-specific approaches used for developing and demonstrating attainment of the critical human health protective concentrations for dioxins, furans, and dioxin-like PCBs. This rulemaking could require additional time and resource expenditure, both by regulated entities involved in certain remediation division programs and by the Superfund program itself. However, the change would only affect a small number of sites currently, and the rulemaking would result in updated and flexible human health PCLs for these specific chemicals. This would be more protective of human health and would also allow the ED flexibility to adapt these levels in the future to reflect the latest science. We note that the public involvement plan and alternative language requirements have been properly proposed, and we will be attending the hybrid public meeting that's now scheduled for September 30th. As always, we will monitor this effort as it progresses and keep the Commission apprised of any public interest issues. We really appreciate the staff's work on this and we support publication. Thank you.
Thank you. Colleagues, I certainly think it's appropriate to revise these rules and not ready to put this particular proposal out for comment.
I move that we approve the publication of and hearing on the proposed amended sections of 30 Texas Administrative Code, Chapter 350, as recommended by the Executive Director.
A second motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Okay, item 63 is our public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except the commission cannot hear about pending permitting matters or other contested cases, which are subject to ex parte prohibitions found in the Texas Government Code. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given is limited to statements of specific factual response or the recitation of an existing policy. And with that, it seems we had 4 people sign in for public comment, and we'll begin with Errol Summerlin. They're all virtual too.
Great. Errol Summerlin, are you with us?
Yes, sir. Can you hear me?
Loud and clear. Go ahead when you're ready.
All right. Good morning, commissioners. My name is Errol Summerlin. I have a home of 40 years in Portland and am co-founder of CAPE, the Coastal Alliance to Protect Our Environment. Last month, I asked you to consider setting a specific time to receive public comment during your meetings. That change was not implemented for today's meeting, so I once again ask that you do so. Last month, I spoke of the unrest in the coastal bend. The area has been totally transformed over the last 10 years, and the current industrial initiatives underway with new ammonia and hydrogen facilities, together with this insane idea of capturing the carbon and injecting it into an area with abandoned wells and fault lines, invites degradation to an entire ecosystem and way of life. Which brings me to the restrictive use of the term affected person in determining whether a protestant is granted a contested case hearing. We've all heard about the 1 mile rule that is or isn't being used. It was used this morning to deny standing to an entire city that was 2 miles away. Let me tell you something about Corpus Christi Bay and its people. We have a public right and a duty to protect our bay. When you constantly inject the discharges from the industries along the inner harbor, together with those discharging into the La Quinta Channel, and then include the brine discharges that will come with multiple desalination facilities, there is more than an affected person. It's an affected public at large. A kayaker, a sailor, a commercial fisherman, a recreational fisherman, birder, a waiter, a surfer, a honeymoon couple, all jointly benefit from the bay's abundant bounty and moments in time that just soothe the soul. Every time you issue a new permit or increase a facility's discharge, a multitude of individuals are affected, not just those near the source point. How can it be correct to say an affected person has to be affected in a manner not common to members of the general public, when it's the public at large that is being affected in so many varied and important ways? I speak in the context of water, but the same principle applies to air. You don't have to live on the fence line to suffer health consequences from industrial emissions. Broaden the justiciable interest that can be protected. When it comes to Corpus Christi Bay, even an old man like myself, who pulls his pant leg up and wades along the shallow bay waters, feeling sand beneath his toes, watching a heron fish for its dinner, all the while watching his grandkids do the same, has a personal interest in protecting the bay from degradation, protecting that space and time, now and for future generations. You must recognize that, and it's where you can take a big step towards protecting the real public's interest. I want to thank you for your time today.
Thank you, Mr. Summerlin, for your comments. We appreciate that. Ms. Smith, who's next?
Muted.
We have Autumn Hensick.
Ms. Hensick, good morning.
Good morning. Thank you, commissioners. Yes, my name is Autumn Hensick, and I am calling in today from Corpus Christi. in order to speak about some concerns that I have just regarding TCEQ's lack of oversight here in my home. I do want to state that I believe a full cumulative impact study should be performed before any further expansion is allowed in my home here in Nueces County, as well as the neighboring county of San Patricio. Seeing as industries just continue to expand with no regard given for damage that they're already causing to my home. There are so many individual permits that are really obviously intended to distort or hide the total cumulative emissions and environmental impacts. And yet industries, so close to me like Cheniere want more. I've been one of almost 500 community members here that has been emailing and writing handwritten letters to Cheniere's CEO with no response, pleading with this facility to consider swapping gas combustion turbines that they are still using at their Corpus Christi site, which we know emit benzene and formaldehyde, two known carcinogens. We don't have any TCEQ air monitors in Gregory, Texas, where the facility is located. We're having to rely on, an averaging of daily emissions by Cheniere, which gives us just an incredibly inaccurate depiction of the harm that they're doing to us, to the environment. I wanted to speak today because I do believe that the commission ignores cumulative impacts of a facility, even when emission sources are standing side by side, even when they're using joint infrastructure, treating each of those units as a separate single source for determining whether or not a facility meets air quality standards. I wanted to speak today because I also strongly disagree that the commission presumptively considers all permits as minor and not as major. I also wanted to address that, the commission allowing facilities to amend their original air permits, at times multiple amendments, right? And then issuing in these as-built permits that rolls all of these aggregate emissions into one, including permits by rule that are issued, when a facility can't meet those original emission limits. Again, using Cheniere as an example here, they are now allowed to emit almost double what they were in just 2018 when they came to our home. I wanted to speak today because violations that become the subject of these enforcement proceedings are later routinely included as allowable deviations in those permits. And again, I wanted to speak today because I believe that the TCEQ should conduct a full environmental impact study on every air and water quality permit. I thank you for giving me the chance to speak today, and I plan to come back as long as I have to be. Thank you.
Thank you, Ms. Hensick. Appreciate your comments. Ms. Smith, who's next?
And forgive me if I mispronounce the name, but L.A. Coda.
L.A. Coda, are you with us? L.A. Coda? Let's come back. Who's next?
Peter Bella.
Mr. Bella, are you there?
Yes, sir. Good morning.
Hey, good morning. Go ahead when you're ready, sir.
Good morning, Commissioners. My name is Peter Bella. I'm calling from San Antonio, and I'm making comments on my own behalf, although I am supportive of the comments of Errol Summerlin and Autumn Hensick. During the Commissioner's agenda of July 17th, I also requested that in order to facilitate public input, the Commission could adopt a specific time of day for public comments during the monthly Commissioner's agenda, perhaps at the 2-hour mark after the meeting begins, or as the first item on the agenda, etc. During the July agenda, I also noticed that a fair amount of time was spent after the chairman called the next public commenter in waiting for the arrival at the podium or online of the commenter. Please consider allowing public comments to be submitted to you as audio recordings. If we sent you prepared comments as a 3-minute audio file, then with a click of the button, you could play them during the public comments item in the agenda and listen to them as easily as you can listen to the comments I'm making right this moment. In fact, of course, my audio comments right this second could be pre-recorded and no one could tell the difference. This would mean less time spent waiting for the speaker to present themselves to begin their comment and perhaps would facilitate greater concision by presenters. Distinctly, I would also request that the commission allow 3-minute public comments pre-recorded for play during the agenda that were in fact short video clips as well. That is, telling our story, not just as an audio presentation to you, but accompanied by video, which would elucidate our comments, played and visible on the screens in the room during the agenda, would be a very meaningful way from our perspective to present our 3-minute public comments to you. Thank you, commissioners.
Thank you, Mr. Bella.
Kathy Fulton.
Ms. Fulton?
Yes, can you hear me?
We can. Good morning. Go ahead when you're ready.
Good morning, thank you. Yes, my comment, I want to, this is about a Texas Tribune article that came out earlier this year, I believe in January. And it was titled, How Texas Polluters Classify Big Facilities as Smaller Ones to Avoid Stricter Environmental Rules and Public Input. And what this article is about essentially is minor versus major classification, be it air or water. And one of the things from this is, it's actually a very good article. I would suggest everybody consider trying to read it. But it does say if the state turns to look the other way, the permit requirements for these sources deemed as minor could be much less costly to meet. Meaning, if it's minor, they don't have to get oversight from the EPA or go through any more stringent recommendations. The EPA foresaw this problem in the 1990 air permitting manual, labeling such authorizations as sham permits. If a source accepts operational limits to obtain a minor source construction permit, but intends to operate the source in excess of those limitations once the unit is built, the permit is considered a sham. That is what is in the manual. Additionally, a permit may be considered a sham permit if it is issued for a number of pollution emitting modules that keep the source minor, but within a short period of time, an application is submitted for additional modules, meaning an amendment, which would make the total source major. This is something that has been going on. This article cites at least 10 different facilities where this has been happening, be it water or air. Cheniere, again, as you've already heard, is a good example. Flint Hills is another example. I believe Valero is another great example, the recent approval of a Valero permit. And in Cheniere's case, there are 3, right now, I believe there are 3 separate permits, but they're all considered minor, even though we know Cheniere has been.
Ms. Fulton, because Cheniere has pending permits, that's one of the topics that the commissioners can't hear about unless it's publicly noticed, and Cheniere has the opportunity to be here and discuss the topic too. So if you could go back to sort of a more general discussion of your subject, that would be appreciated. Thank you.
Okay, well, in the case of all these, whether it's Cheniere, Flint Hills, Valero, the many other facilities down in the Corpus Christi and San Patricio, Corpus Christi area and San Patricio County area, all of these have been getting minor source permits, but they're all in one facility. So they all combine, and it's not like that permit or that air quality permit stays separate from the others. They're all in one facility. This is where, again, TCEQ is failing us in this state, failing us miserably. And we need you to stop allowing this continued abuse, what's clearly abuse of the system, by allowing continued use of this minor source when we all know it's major. It all needs to be considered together. Thank you.
Thank you, Ms. Fulton.
We'll try Alay Coda again.
Alay Coda, are you with us? Alay Coda? Okay. Just,
I do understand they're not logged into the webinar, so
yeah, I think Alay Coda will have to catch us on the next opportunity for public comment. I can't help myself. I do want to just offer some comments in response to Ms. Fulton's concerns, and that is this. Congress, through the Federal Clean Air Act, laid out a distinction between major and minor sources. That is the legal authority that we implement, including EPA rules and guidance and TCEQ rules and guidance that have been adopted to interpret those distinctions. And if TCEQ or EPA, for that matter, fails to follow the legal requirements, or if a regulated entity fails to follow those requirements, there are enforcement mechanisms under law. And that includes enforcement mechanisms to invalidate so-called sham permits. And these include enforcement by EPA, by TCEQ, and in some cases, citizen suits. So what we're responding to is the current state of the legal authority, and how a publication may wish to characterize this is one thing. The way a court will analyze the issue when the matter is brought before them is what I'm really concerned about. And so we try to be sensitive to that, and that's what this commission focuses on. So forgive me that public comment, but colleagues, anything else on the public comment session? Okay. All right, Ms. Smith, I think we're ready to call the next items.
the next items are for closed session, and the commission will meet in closed session in room 246 of the Workforce Commission at, we say, 10:37. Does that sound good? As permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items numbered 64 through 67 as posted and noticed.
The time is 10:32 a.m. We are in recess.
The commission met in room 246 of the Workforce Commission for closed session from approximately 10:37 a.m. until 10:40 a.m. on item number 67, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned and the time is 10:45.